Hello everyone, Katie Byer here. My presentation that I will be recording is on Chapter 3, Case Study 2, Misplaced Affections, Discharge for Sexual Harassment. So, there we go. Let's start with the people involved and where it happened. So, this case takes place, I don't know if that's the actual building, but I just put a picture for vibes. The case takes place at Simpson Elementary School in the Pine Circle Unified School District. We have Peter Lewiston, who is a senior maintenance worker with an 11-year above average record. He's known as friendly, but also lonely after becoming a widower. And then Beverly Gilbury was a married fifth grade teacher who had been with the district for 6 years. So the situation began to escalate toward the end of the school year. In 2020-21 school year, Lewiston started paying Gilbury unusual attention, which she initially tried to gently deflect. Excuse me, that's my dog. Sorry about that. On May 25th, over here on the timeline in the middle, when he complimented her eyes, she firmly told him that they were just friends. So despite these clear boundaries, on the first day of summer school, mind you, Lewiston sent her a dozen roses, multiple romantic cards or letters, if you will, and repeatedly asked her to lunch. So that was over here on June 7th/8th. So then this takes us to the climax, which occurred on June 8th. So this is when Gilbury was trying to leave work one day and she was walking to the parking lot and Lewiston ambushed her at her car, and she became agitated and tried to leave. So he reached inside her vehicle and touched her head, like almost like a pet. Excuse me. All right, so the climax officially occurred on June 8th when Gilbury was trying to leave work and walk to her car in the parking lot. Lewis ambushed her. And so as she became agitated and tried to leave, he reached inside of her vehicle and touched her head or tried to like pet her hair. Oh, sorry. So this severe crossing of physical boundaries prompted her to file a formal EEOC complaint. Like she's had enough by this point. So this was to get an initial court injunction on June 11th, right here on our timeline. So though that injunction was later set aside when she didn't appear in court, ultimately the district's investigation into her complaint led to Lewiston's termination on July 15th. All right, so looking at the first case question, evaluating the conduct of Peter Lewiston, his actions definitely align with the EEOC's definition of a hostile work environment, as well as sexual harassment. So as unwelcomed advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature in the working environment. A hostile environment occurs when this interferes with an employee's job performance or creates an intimidating workspace and, they're scared to show up to work just because of fear of the unknown. Lewiston repeatedly pushed romantic advances or feelings onto Gilbury despite her explicit rejections, telling him that she was happily married and creating a whole situation where she became fearful and agitated. Oh, okay. Moving on to question 2 was, should Lewiston's intent be considered? So legally, I believe the answer is no. Even unintentional discrimination can be illegal. So the law focuses on the impact of the conduct on the victim, not necessarily the harasser's motive. So even if Lewiston genuinely thought he was calming her down at the car, his persistent, unwanted actions created a hostile environment for Gilbury that she kind of wanted to act upon. For the third and final question, if I were the district EEOC officer, I would conclude that a sexual hostile work environment was absolutely present. Employers are required to take corrective action. So Equal Employment Opportunity Commission is what EEOC stands for. So this is work that consists of formulating EEO policy and approving all litigation involved in maintaining equal employment opportunity. So the EEOC's guidelines are not federal law, but administrative rules and regulations pushed in the Federal Register. Therefore, I would strongly support the district's decision to pursue severely disciplinary action up to and including termination, especially given the physical escalation of the entire car incident. So how exactly does this tie to our textbook and our course, what we're learning? So Chapter 3, this case is deeply rooted to the Title VII of the Civil Rights Act of 1964. Specifically bars employment discrimination in all HR activities, including hiring, training, promotion, transfer, pay, employee benefits, and other conditions of employment. Discrimination is prohibited on the basis of race, color, religion, sex, or national origin. Title VII of the Civil Rights Act also created the EEOC to administer the law and thereby promote equal employment opportunity. So this also includes the legal concept of a hostile work environment. So this recognizes that verbal or physical harassment of a sexual nature can illegally disrupt a person's working condition. Another crucial and significant course concept here is employer liability. So the EEOC holds employers guilty of sexual harassment if they knew about the unlawful conduct and failed to remedy it. By thoroughly investigating Gilbury's complaint and subsequently terminating Lewiston, the school district fulfilled its legal obligation to take corrective action and protect its employees and make them feel safe coming to work every day. All right, so broadening our analysis, let's take a look at the impact of the Me Too movement. So nearly 1/3 of executives said that they have changed their behaviors to avoid any behavior that could be perceived as sexual harassments. So this movement shined a bright light on cases just like Gilbury's, leading to a 50% increase in EEOC lawsuits that year. So it forced companies across the country to drastically overhaul how they handle complaints and implement new organizational training, which we will discuss later. However, these modern challenges do remain throughout today's society. But following the initial surge of the Me Too movement, the reporting of sexual harassment actually dropped from 55% in 2017 to just 45% in 2020. So additionally, human resource professionals must constantly adapt to evolving legal definitions under the Title VII Act. For example, as noted in Chapter 3, again, the landmark 2020 Supreme Court decision in Bostock versus Clayton County expanded Title VII to protect employees against discrimination based on sexual orientation and gender identity. So cases like this, misplaced affection, and rulings like Bostock highlight the ongoing critical needs for rigorous, up-to-date EEO policies and comprehensive training for all employees across the board. So with that, I'd like to end with a few questions for our discussion board or forum that will be watched by, I think, Sunday night, it said. So first, do you think that the termination was the only valid option for Lewiston, or could a transfer to another school have sufficed? Second, how should human resources proactively handle boundary crossing by, I guess these lonely widower employees before it escalates? Because I'm sure there are other lonely employees that cross these boundaries. And then third, what specific training could the school have provided to prevent this entire situation? But here are the resources and references I used for this case presentation, including our textbook for chapter 3, and with the misplaced affections case study within that. But thank you for your time and watching my case presentation, and I look forward to reading your answers to those last 3 questions, or any additional questions you have for me, along with any corrective or additional feedback. So, thank you.